Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to the award-winning Serious Privacy podcast sponsored by TrustArc. Please welcome your hosts, Paul Breitbart, Ralph O'Brien, and Dr. Kay Royal.
From Europol to New Mexico, from the Netherlands to Russia, and from California to Canada, this must be a Week in Privacy episode. My name is Paul Breitbart.
And my name is Ralph O'Brien, and welcome to Serious Privacy. This is superb, Paul. Not superb, of course we miss Kay. Of course we miss Kay. But
were you going to say this is superb, this is going to be a men's-only episode?
Not at all.
This is a manel.
Yeah, a manel, my God. Yes, just circumstance. We should, of course, represent the diverse range of opinions as we can, of course. I was more surprised by how quick your introduction was, but we do actually have a lot to talk about because the world doesn't stand still while we have guests.
Nothing major, but they are all nice, small topics, I would say.
Indeed. So, I'm going to do the unexpected question for a change. And this is just one I've randomly pulled, so I haven't had too much notice. I don't even know what I'm going to say yet. Random question from the internet. If you were a car, what car would you be? Why would you choose that particular make or model, Paul?
I would probably be a Volvo 760.
Okay.
Nice and reliable, goes on forever, quality stuff. I'll also tell you what I wouldn't be. I wouldn't be a Yango taxi.
You wouldn't be a Yango? I will get to Yango taxis in a minute, of course, yes. Yeah, I think for mine, let me just think. Look, I'd have to be something that wasn't a gas guzzler. But having recently got an electric car, I have realized how data slurpy they are. So an app for everything. It'd probably be something manual. And because I've been going to the gym for the first time in forever all week, feeling the aches and pains in my bones and muscles, I'd probably have to be something old and knackered and manual as well. I think I'd go for a good old reliable sort of Toyota Estate or something along that line as well. I should say some sort of sexy Aston Martin or something like that.
You don't want the Flintstones car where you actually need to do the exercise to get the car driving.
When the heels hit the road itself, yeah. I've owned cars where they fall apart enough. That's certainly an option. There we go. So you mentioned taxis, Paul. Shall we start there?
I did mention taxis. Yes, we can start there. And this is a fine that was imposed by the Dutch Data Protection Authority at the start of the month, a fine for the taxi app Yango. And Yango, actually the company behind it, MLU BV, which is established here in the Netherlands. Yango is a taxi app similar to Uber or other ride-sharing apps, mainly used outside of Russia in Norway and Finland. There were complaints against this app for alleged illegal data transfers back to Russia. So the Dutch DPA, as lead supervisory authority for the headquarters of the company, together with the data protection authorities in Norway and Finland, has investigated. And the investigation shows that the app indeed collects and stores a significant amount of personal data, both customers and drivers on servers in Russia, including some sensitive data. For example, scans of driving licenses, home addresses, contact details, account numbers, exact location, trip data, images, chat conversations, and also social security number. So sensitive, not necessarily special categories of data, but it's all going to Russia, where, as we know, data protection law is not as strict as in the European Union. There is no adequacy. There were no proper safeguards in place. Yango has received a fine of 100 million euros for all the contraventions made so far. And they have also received a compliance order to immediately seize all data transfers to Russia. And I think this is the first major data protection case against a Russian company. We've seen issues, of course, for data transfers to the US. We've seen data transfers to China, but I think this is the first one that is for a different country. A fine, 100 million, and it's not even a cease and desist. It's actually a processing prohibition. That means that it will not be conditional immediately to an additional fine. Although if the processing continues, obviously the Dutch DPA can further impose sanctions. But for now, it's 100 million euros and the obligation to stop processing. And that means all the data transfers of Norwegian and Finnish users of the Yango app to recipients in Russia. MLU has announced that they will appeal the decision. As far as I'm aware, this will probably end up before the courts in the not too distant future.
Yeah, it is interesting, isn't it? You issue a penalty of 100 million. I don't think there's many companies that's probably just going to roll over and go, okay, then, cost of doing business. So you start issuing 100 million, there'll be a challenge in the court somewhere. Just remind me, Paul, I'm not familiar with the administrative law of the Netherlands. I take it whilst the appeal is happening, they're not going to stop the processing.
They have to, because that applies immediately, at least until they get a court to rule on it. That's a possibility. But this is a processing prohibition. So I would say that this applies actually straight away. Whereas if it would have been a cease and desist order, then it probably wouldn't apply until the end of the appeals process. This is effective immediately until a judge would say we suspend the decision pending review.
Okay. Yeah, no, that's absolutely fascinating because we've often said, and I think we've said on the podcast before, the ability of a regulator to say, stop processing personal data or stop transferring personal data is, to me, far more impactful than financial penalty because that'll shut you down, right?
It could for sure. And especially in this case, I don't think if your app is built to host everything on a server in Russia, and that's the way the whole app is designed. We've seen how long it's taken TikTok to establish their US entity and ensure that all the data is kept on US servers. That took, almost 18 months, I think, between the first announcement that law was coming and it actually happening. So in the interim, I don't believe that this company, Yandex, would be able to just at the snap of their fingers be able to stop all data transfers to Russia and make sure that the app still continues to work. But we'll see. It's an interesting fine. It's not at the exact maximum that the GDPR would allow. Obviously, 4% of global turnover. Turnover for the mother company, which is called RightTag, is converted into euros just over 12 billion. The maximum penalty would have been 483.2 million euros. And the Dutch DPA have taken, about 20% of that. So it's far from the maximum, but that also means that there is still some room for further enforcement if need be.
That's amazing. Yeah, I've got a sort of an issue around enforcement in general. We were just talking before the call. So I'm always a fan of seeing a regulator use the full range of their powers, not just the financial penalties or reprimands, but the full range, including everything from a naming and shaming or a light tap on the wrist to a notification that they might be breaching, or as you said, full prohibition.
Yeah, processing bans are, in my view, the best way to enforce, especially in scenarios like this. And I'm also happy to see that it's not yet an American company, but it's actually another jurisdiction that we are looking into. And the report, which is only available in Dutch, but also has an extensive analysis of the applicable legal framework in Russia and also of the corporate setup of Yandex. So you can actually follow along pretty well how all of this is done, what the conclusions of the DPA were, how this is dealt with from a legal perspective. So I'm hopeful that this will also hold up in court. That will take a while. So this will no longer be the problem of the current chair of the Dutch DPA, Aleid Wolfsen, who comes at the end of his mandate on the 1st of August, but of his successor, Geert Potjewijd, which is internationally, of course, an impossible name to pronounce, Potjewijd. But he has been appointed last week as the new chairman of the Dutch Data Protection Authority. He is a data protection lawyer. He has a lot of experience on the topic, used to co-head the data protection and cybersecurity practice at Dutch law firm De Brauw Blackstone Westbroek, and has also been chair of the board of that law firm. While lawyer there, he represented Meta and TikTok, among other companies, which in my view is to be expected if you head up the practice at a major law firm, that you would also get big tech. But that obviously is also immediately the criticism that he receives. Oh, it's big tech lawyer taking over at the helm of the supervisory authority.
I've already seen that from Noib. I think Noib commented on that almost straight away.
Yeah, there are some others. And I understand the criticism. At the same time, I've met him, I've worked with him in the past, and I'm more than happy to give him the benefit of the doubt. And I'm really happy that we have actually a data protection lawyer who will be at the helm of the supervisory authority.
No, it is interesting. I've been working in the UK, and we've had similar criticisms as well. William Malcolm, who was working for Google for a long time, moved into a regulatory role at the ICO, for example. It is interesting because you're going to work together with a lot of big tech companies, and therefore big tech will obviously have a valuable perspective. With the Irish regulator, we saw people from big tech move in.
Those were coming directly from big tech and not one step removed as their independent, I would say, lawyer.
The digital omnibus, we saw that being headed by somebody from big techs as well. So there is a sort of an opinion out there about regulatory capture. There is an opinion out there about regulatory capture. I totally take your point about law firm being one stage removed, even if instructed by. Yeah, something to think about.
While at the topic of regulators, I don't think we've spoken yet about what's happening at the Information Commissioner's office, or should I say the Information Commissioner?
Yes.
Or the Information Commission. I'm confused where we stand.
Okay, so in the UK, actually legally, we have an Information Commission and an Information Commissioner's office at the moment, but there has been no secondary legislation passed to transfer the assets from the Information Commissioner's office to the Information Commission. So technically, the ICO and the IC are running at the moment. It's just that we haven't transferred assets and power from one to the other. So we've got two regulators at the moment, but we'll see what happens as we go on. But I think you're, of course, referring to John Edwards. John Edwards was after his speech at IAPP, where he said it would be his last speech as the commissioner. And I think at the time we were all referring to the fact that he was going to become the chair of the Information Commission, and his tenure was going to run out in January 2027 anyway. Now, I think we're going to have to draw everybody's attention to a letter that's gone from Paul Arnold, who is the CEO of the Information Commission, to Parliament. And that letter states that John Edwards has voluntarily stepped back from his duties pending an HR investigation. Now, we have to be very clear here. Due process has got to happen, innocent until proven guilty, and until there's an outcome of investigation, perhaps we shouldn't talk about things too much. But obviously it is of note that John Edwards is not allowed into ICO premises or to interact with the staff apart from his private office. And in the meantime, it's business as usual for the ICO, because Paul Arnold, who was appointed as the interim CEO on that transition to the Information Commission, has taken the helm, as you would do under delegated powers, in the ICO's absence.
Yeah, indeed. And first of all, I'm sorry for John that this happens, even though he and I have not always seen eye to eye. These kind of things are always, whatever the outcome, a personal trauma. I hope it will be over soon, and that there will be a clear decision one way or the other for all people involved. As if there is more news on this, we will keep you posted. I do admire the fact that there are no rumors whatsoever about what would have happened, could have happened here. So it's clearly a very professionally run, close-hold investigation, and let's hope they keep it that way.
Yeah, even in the letter from Paul Arnold to the Department of Science, Innovation and Technology Committee that sort of looks after the ICO, it was more about reassurance about service continuity than personnel matters that should probably stay personal, of course. You'd hope that the Data Protection Commission, or the ICO in our case, would understand the nature of personal data confidentiality. So, yeah, I don't think it's right to speculate, but at the same time, it is relevant to the developments, especially as in the UK, we go through that time of transmission, moving from one to the other. On the basis of news at the ICO, there's a couple of short updates that I can give. However, on the 19th of June, we're going to see more commencements of the Data Use and Access Act, and that is to have a data protection complaints process. Now, my argument has always been like, we should have had one in the first place, but this is a requirement on controllers to have a formal process that individuals can press the button on, where they have to respond and at least acknowledge the complaint within 30 days, go through the complaints process before they can contact the regulator. So you might well consider it a retrograde step, because an additional hurdle for the data subjects, they can't go straight to the regulator. But equally, the regulator has actually published guidance that said if it's serious enough, they would consider it. So I'll take that sort of point with a point of salt. But in terms of business as usual, there's two more updates from the ICO. One today was actually a Glasgow-based energy company, 160,000 for unsolicited marketing calls without checking the telephone preference service or the corporate telephone preference services, which resulted in a number of complaints to the regulator about essentially unsolicited communications, unsolicited phone calls. And that's resulted in 160,000 marketing fine under PECR, a PECR, which is our implementation of e-privacy. And the other bit of guidance that the ICO has put out recently is, I think, somewhat controversial. As with the Data Use and Access Act, the ICO has got a new mission, or the Information Commission will have a new mission. And the primary of that mission is to promote the economy and innovation. And so they have issued some advice to government on how to change PECR, Regulation 6, which is about consent requirements for online advertising and cookies and things like that. And they have recommended, this is William Malcolm's statement again, that they have recommended changes to the government on how to change Regulation 6 to have better uses of advertising technologies that allow low-risk forms of online advertising to operate without consent, whilst continuing to require consent for advertising that involves intrusive tracking and profiling. So an interesting piece of advice from the regulator on how to use technology and change the law in a way that, in my opinion at least, would erode the current state of the law. That hasn't gone down well, as you can imagine.
Yes, I can imagine that. More money to be paid, in this case in Spain, total fine of 120,000 euros to Tiger Media Incorporated, which is an operator of an adult advertising network. And they were relying on legitimate interest for their cookie and cookie subsequent processing. The regulator rejected this because they say no, non-essential advertising cookies require consent. So legitimate interest cannot repair an unlawful cookie deployment. And this is notable because the AEPD, the Spanish Data Protection Authority, also treated the advertising network itself, and not only the publishers using it, as a controller under data protection law, responsible for all the downstream processing. So even though Tiger Media argued that it's only the publishers responsible for consent collection, the APD concluded that the network determined purpose and means, and therefore, in line with Planet 49 and also other case law from the Court of Justice, they are actually directly responsible for compliance. There was also the small issue of this being adult advertising. Even though no special category data was explicitly processed, browsing in this context would be sensitive because the cookies related to visits to adult content websites, which of course may still imply certain sexual preferences, which in turn would be special category of personal data, and that increased the gravity of the infringement and therefore also the fine calculation. Finally, the APD also said that this Tiger Media company failed to appoint a valid EU representative under Article 27 GDPR because their representative was in Northern Ireland, which the AAPD reminded everybody friendly is not part of the European Union anymore since Brexit. So also for all the other companies out there thinking, oh, but I have a UK representative, that's enough, isn't it? It is not, and it is also enforced. So 70,000 euros in fines for the unlawful processing of the cookies, 50,000 for the Article 27 violation, so the non-appointment of the EU representative. In the end, that was reduced to 72,000 because the company admitted liability and paid voluntarily. But on top of the fine, there is a compliance order. Everything needs to be shipshape within 3 months of the fine.
Okay. And again, it's interesting to see EU representatives being included there. Again, not something you often see enforcement on. So,
Nope.
Yeah, that's really interesting. I do know one of my friends who runs a representative company. He'll be quite happy to see that judgment.
Does he run it on mainland Europe or in the UK?
Both, actually. And in Switzerland, as it happens as well. All of which have got representative functions, not just across the GDPR, but across all of the other suite of laws as well, the DSA and all of those other European laws as well. Yeah, don't forget your EU rep or your UK rep or your Swiss rep.
Don't forget your rep.
Don't forget your rep, indeed. I've got another one here, our good friend AI again, and I'm not going to spend too long on this because I haven't read the entire paper, because the paper itself is 167 pages with 2 annexes. And yeah,
what paper are you talking about?
This is the European Commission's guidance on high-risk AI systems under Article 6 of Regulation 2024-1689 that we would know as the AI Act for stakeholder consultation.
Seems like that's my reading for the Pentecost bank holiday on Monday.
167 pages, which is interesting. And I think the main thing that I've read that I really like in there is they are really focusing on it again as a product safety element. Yeah. So what is a safe function and what is the failure or malfunctioning state, which I think is an interesting kind of conversation to have. And then they go through and try and do a load of classification as to what is and isn't a high-risk AI system. I'm not going to speak too much further on it, apart from advising people who are utilizing AI systems to go and have a look. But also, one of the things that they actually said is that, in fact, if you have meaningful human intervention, that doesn't stop it from being a high-risk AI system, which I thought was an interesting one. Just because you've got humans involved. So from the GDPR point of view, we'd say, hey, if you've got humans in the loop, then automated decision-making, it says you cannot do it solely without humans, right? Whereas in the AI Act, it says just because you've got humans in the loop doesn't stop it from being a high-risk AI system. And I thought that was a really interesting point to bring out and note there.
Yeah, agreed. Let's briefly turn to the US.
Ooh.
I have a nice case from California. We already knew that California was looking quite a bit at car privacy and driving data and things like that. They have now announced that they have reached a settlement with General Motors and OnStar following GM's illegal sale of Californians' location and driving data to data brokers. This all happened between 2016 and 2024, part of which falls within the scope of the California Consumer Privacy Act. So that is something that could be enforced. And this is data, consumer data collected by General Motors, such as vehicle speeds, braking, acceleration, parking data, all of that. And that was resold to LexisNexis Risk Solutions and Verisk Analytics that would then sell it on to car rental services, who can then determine based on all that data what the risk premium would be for car rental. So the California DPA concluded that this was a violation of the CCPA because there was improper notice, there was a violation of the purpose limitation principle, a violation of the data minimization principle, and it was also misleading consumers about data sales to data brokers. GM and OnStar have to pay 12.75 million euros in fines, but on top of that, they need to stop selling driving data to any consumer reporting agencies for 5 years, including any data brokers, obtain consent before collecting, using, or disclosing driving data, give consumer privacy notices during the enrollment process for such features, enable consumers to disable GM's remote collection of all data from their vehicles, and develop and maintain a privacy program for 5 years. So it is a pretty steep and encompassing settlement, I would say. Somebody at GM must not be happy with this.
No, indeed. And from America, there's one that's got the potential to be even bigger as well. New Mexico, they have found Meta Group in a second phase of a lawsuit brought by their attorney general. Not only have they found them liable for child safety failures up to $375 million, the state has also petitioned for another legal sanction against the company, 10 times the original amount, which could be $3.7 billion in an abatement plan. And again, they're stipulating that the money would fund programs for law enforcement, mental health service, and educators. So they've even said where the fine would go. And not just they want the money, but they want the judge to force a series of design changes to improve child safety, including XI, universal age verification, decryption of children's messages, a guardian account linked to every child account, and a child safety monitor tasked with holding Meta to account. Now, I like the last one, the child safety monitor, but the other ones does seem to almost violate the privacy of the child in that sometimes we look at children as a risk category. I totally agree we should try and protect children as a vulnerable category of data subject. But I think sometimes we forget that they're autonomous beings with feelings in themselves that sometimes may need a safe space free from parental supervision. Whilst I fully support their sort of child safety online, at the same time, collecting more data on all of us for age verification and enabling children safe spaces, not necessarily in my wheelhouse. You may feel differently.
I do not. And I actually have something about children's data as well in an even more serious context, I would say. And that is the law enforcement context. The Coordinated Supervision Committee of the EDPB, which is responsible for supervising Europol and Eurojust and other EU-based agencies dealing with law enforcement matters. They have investigated Europol's processing of the data of minors under 15 as suspects or potential future criminals. And this has a reason. The evaluations done on a regular basis of what data Europol has show that there is an increase of data related to minors under 15 in their systems. And that in turn is because we see that minors under 15 are more and more involved in serious crime across the European Union, mainly fireworks-based bomb attacks, arson, and those kind of things, but as part of large criminal networks. That's a concern all over Europe. So it means that Europol has a title to investigate. But obviously, Europol may only process minors' personal data if that is strictly necessary and proportionate for preventing or combating serious crime within their mandate. That applies to all under 18s, but certainly for under 15s. And labeling these children as suspects or potential future criminals could also have a stigmatizing effect. The investigation showed that indeed categorization sometimes is weak in Europol systems, that records are not always well kept. Some minors were labeled as suspects despite apparently only having peripheral involvement, and also the national logs of what had been sent to Europol are lacking. So this is not just a Europol issue, this is also an issue with the national police forces sharing data with the European Police Agency. So there needs to be better documentation of why the data is actually in the system. There needs to be stronger data quality and data quality controls, and also better processes to correct inaccurate age data to ensure that this is not turning into something that it shouldn't be, stigmatizing these children. Originally, the intention was that this would have been a one-off exercise, but there are now plans to make this part of structured supervision, at least until matters are a little more under control.
I feel a blog post coming on It's probably too much for the podcast. It's the state of children online and some of those concepts we were just talking about whether to treat them as a category of risk or as autonomous beings in themselves. It'll be on seriousprivacy.co.uk by the time this episode. I can assure you of that. 3 very small ones. Louisiana's comprehensive privacy bill looks like it's being voted on as we're recording. I'm sure Kay will tell us more about that. The US Take It Down Act has entered its enforcement phase. So that's an interesting one. And a little bit of news for data protection professionals, because you're, of course, listening to the Picasso award-winning Serious Privacy podcast, is that even though we won last year, the world keeps turning and the Picasso Award nominations are open for 2026. And so too are the Picasso Africa Awards.
Yes.
Are open for 2026, which you might find has developed a new judge recently.
Would that judge be a co-host on this podcast, coincidentally?
You never know. We'll see what happens, shan't we?
Completely respectable and non-bribable, obviously.
Indeed.
So maybe to wrap up, our friends at OpenAI have also been under investigation by our better friends from Canada. The Office of the Privacy Commissioner of Canada, Alberta, British Columbia, Quebec have jointly investigated OpenAI following some complaints that the company, and especially ChatGPT, would engage in data collection and processing without valid consent. And indeed, finding was that OpenAI is over-collecting users' personal data to train their models, including sensitive information, do not have valid consent from users before collecting that information, do not have any mechanism to verify the accuracy of the information contained in the outputs, fail to provide effective access correction and deletion mechanisms, and fail to demonstrate accountability before launching ChatGPT. I don't think anyone would consider that this is a surprise, at least these findings. OpenAI has made some commitments and will implement further safeguards in new ChatGPT models. It's unclear as yet if that will only apply to Canada or whether they will be responsible and make those safeguards available in all countries.
Yep. We'll see how that pans out. I guess we'll see how that pans out.
And on that deep sigh, we end another episode of Serious Privacy. Thank you all for listening. Until next week, goodbye.
Goodbye.
Now that was Serious Privacy. Please subscribe on your favorite podcast app and leave us a review. You can find us on LinkedIn, Instagram, and Blue Sky as Serious Privacy. Feel free to drop us a question or a comment. We'd love to hear from you.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.